Welcome to Channel 17, the Town of Colonie Government Channel.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our legal system, our justice system, and how they intersect with the citizens of the town of Colonie. Today, we are truly fortunate to have as our guest attorney Andrew R. Safranko, who has been practicing law for over 10 years here in the Capital Region. Mr. Safranko is currently affiliated with the law firm of O'Connell and Aronowitz in downtown Albany. And as many of you know, Mr. Safranko has been involved in many celebrated cases throughout the Capital Region. And welcome, Counselor, to our show today.
Thank you, Judge. Thanks for having me. I'm glad to be here.
Well, we're thrilled, and so many times I pick up the newspaper and I see that you've been involved in one case after another, and it's certainly very exciting for all of our viewers to see the man behind the case in so many ways. Most recently, you were involved in a celebrated federal criminal case, and I know that during the summer you had a jury trial conducted over the course of many days in Saratoga County Court, and among other involvements. And we want to take the time to briefly explore some of those cases and also your views on the legal system and justice system. You've spent time both practicing in federal court and state court, is that correct?
Correct.
And certainly most recently and newsworthy was your involvement representing, I believe, Christopher Ortloff in the matter of the United States versus Ortloff, which was a case that certainly garnered front page news throughout the Capital Region. What was involved with that case?
Right. That was a very interesting case, which actually gets into a lot of differences between federal court and state court practice. Chris Ortloff, at the time of his arrest, was a member of the New York State Parole Board and had been a 10-time elected assemblyman from Clinton County from the Plattsburgh area, and very celebrated member of the assembly and very outspoken and in his support and against sex offender legislation. So when he was arrested for child enticement activities and involvement in coming to actually Colonie, to a hotel in Colonie where he thought it was arranged to meet two alleged minors, he was completely out of character and out of the realm for someone who has been such a pillar of the community and such a stalwart against sex offense crimes. He was charged in federal court with child enticement, which carries a 10-year mandatory minimum sentence of 10 years. And whereas if he was charged with the same crimes in state court, he would have faced a maximum of 4 years. So it was a real interesting case as to where the case is going to be heard. Obviously, if it was in state court, it would have been much better off. It was a New York State police sting. I personally had been involved in 2 or 3 other cases that involved the same sting, and those cases were all in state court. And one of the people in that case received a sentence of 6 months in Albany County Jail with 10 years of probation. Another one received a sentence of 3 years incarceration in New York State Department of Corrections. So now we're in federal court facing a 10-year mandatory minimum, and if we didn't accept that, the potential to be charged with a worse crime where it would have been facing a 15-year mandatory minimum.
Counselor, in your vast experience in criminal law and certainly in both state and federal courts, who makes the ultimate decision whether it'll be prosecuted by the federal prosecutor or a local district attorney? And could they both actually simultaneously bring charges against somebody?
They both actually and absolutely could bring charges against one another, and they have the absolute right to do it versus the federal and state law. Fortunately, in this jurisdiction, most of the time, the district attorney's offices and the U.S. attorney's offices get together, and there generally is usually one prosecution. Now, certainly there could be two, and we're fortunate, at least our clients are fortunate in this area, that they seem to get together, and especially in the sex offense realm, the federal prosecutors get the right of first refusal. So they get involved with the police as to what are the elements of the crime, who's involved, what's involved in the case, and they make the determination if they want to handle it in the federal court or they want to, have it remain in state court.
Now, did you find during your involvement on behalf of Mr. Ortloff that the case proceeded right through a trial, or were there was the case closed short of trial? How did that work?
He ended up entering a plea fairly shortly after he was arrested. He was arrested in October and actually entered into his plea on Christmas, where we had a cooperation agreement was involved in that, and he was able to be released from prison in order to cooperate with the government. He had some information with respect to others that were involved in the child pornography or the enticement arena, and had some ideas that would help law enforcement. So they allowed him to come out for a period of a few months after he pled guilty, and that was a condition of his release, was that he had to plead guilty first.
Okay. Well, certainly that was a notable case, but you've been involved in so many, some not necessarily so front page, but nonetheless very meaningful and very powerful, not only to your client, but to the local court systems as well. But you don't always merely handle criminal matters. In fact, recently you've been named as in connection with your driving while intoxicated representation. Certainly you've been recognized as one of the state's premier attorneys in that particular field as well, which I can tell you from my own courthouse, certainly very involved, and routinely Colonie Court on every Monday night will have brand new allegations of driving while intoxicated into the courthouse, and the numbers continue. And I know that certain modifications have been made recently by the state legislature to continue to develop laws against driving while intoxicated with a variety of more severe penalties. Even most recently, Leandras law, and now the interlock requirements for anyone convicted of the misdemeanor of DWI.
Right.
What's your take on the world in DWI law now?
It's a very harsh realm, and it's probably the one true crime where, but for the grace of God, goes anyone on any given night. Anybody could go out there. It doesn't go through race or class or gender or any of those types of issues. It could happen to anyone. I am not a big proponent of policies on any type of case. I believe that every criminal defendant has a right, that we have a system, and that they shouldn't be, categorized, and every case is different, and there are different nuances to every case. With respect to Leandras law, it's particularly harsh based on the fact that there's, again, disparate treatment between different people who were to get arrested with that law. If I were to get arrested under Leandras law, which is, driving while intoxicated with a child in the car, or you, or a doctor per se, and we get convicted of that charge, we could have no prior record whatsoever on anything, and we've now got a felony and a license. We just lost our ability to work, just lost our ability to practice law, of which we had to go to school for, to obtain a license for, and now we're told that, that we can't work, versus someone that's not in a profession. And I'm not saying that driving while intoxicated with a child in a car is acceptable or good, but the punishments are unfairly, can be administered unfairly to people in a professional standing.
Well, and there's no question, we've all seen some news reports over the past year of professionals who have been gotten involved in allegations such as this, and it certainly has put their own license to practice in jeopardy, if not forfeited.
Right, and that's a scary proposition, and it goes again into the new law where on a misdemeanor conviction you have to have the interlock
That's right.
device, and who's going to monitor it, who's going to pay for it. I don't believe the probation departments have enough of them or around for as many misdemeanor convictions there are going to be, and especially in this county with the policy that anybody above .14, even if it's a first-time offense, is not able to obtain a plea bargain to the reduced charge of driving while ability impaired. The costs associated with it are going to be astronomical.
Well, as you know, the judiciary is restrained from policies, and the judiciary is required to look at each case on its own merit, and policies can ensnare and bog down a court system as well, in its ability to continue to fairly and accurately dispense justice if there's a player involved that's just applying a policy without any concern for the facts and circumstances of the particular case, which a court has to do.
Correct.
Yep.
And that's one of the reasons why I've been vocal, against policies, just because every case is different. There's nuances. There's potential probable cause issues with respect to a stop. There's obviously the issues with the breathalyzers having an error ratio and having a firm line in the sand. I just don't believe is a way to react. Because again, every case is different and should be treated differently, because while there may be 1,000 DWIs in Albany, to the actual person charged with that DWI, it's the most important thing to them. Even though it may be a statistic overall in the district attorney's office, the person that's actually charged with DWI doesn't care about everybody else. They care about what's going to happen to them.
And Counselor, even though you've been recognized statewide for your representation and the quality of your representation in connection with cases involving driving while intoxicated, you are involved in a variety of other types of cases too. And we were briefly mentioning licenses and doctors and lawyers and others. And I understand you have found yourself routinely representing physicians, for instance, before the health department on physician discipline issues, and also even nurses or nurse practitioners or physician assistants who are regulated and licensed by the education department, and they've also sometimes are subject to disciplinary hearings. As you go through and defending those healthcare personnel, what's the layout if a physician is charged with some type of a disciplinary action? How does it work, and what type of hearing do you have?
Again, it depends on the type of case, but normally in a physician discipline type scenario, you'll get a notice that they're under investigation for a certain issue, or they'll get a letter requesting certain documents or documentation, and they give you a right to have kind of an informal hearing process to go and see what type of evidence is, what the reason behind the particular type of behavior is, and kind of a way to see if it can be resolved short of going to a formal hearing. If you are to go to a formal hearing, it becomes like a quasi, judicial proceeding. You have an administrative law judge. There's a prosecutor from the Department of Health or from the Education Department, and you put on testimony and you cross-examine and direct examination, just like a trial. And at the end, the administrative law judge would make an overall determination. And in the in certain of the instances, there's boards that meet. So if an ophthalmologist, for example, or a gynecologist were up for review, there would be members of that profession that would be on a panel that would ultimately decide the fate of the doctor if it were to go towards a hearing. Again, obviously, at a physician discipline type of a proceeding, there's very significant consequences if you go forward and lose. Therefore, a lot of them, and not all of them, because we've had some in our office that have actually gone to full-blown hearings, but a lot of those generally try to resolve because the risk versus the reward are so great. You go forward and lose, and you lose your license versus taking some sort of a discipline or probation or a stayed suspension or a suspension can be a lot better than knowing that you may never be able to practice again.
Exactly. What do you find, is there a common theme in your practice of the types of allegations that are made against a physician that bring them before the health department for review?
I would say it varies. You get some for not properly documenting their records, not writing prescriptions properly or keeping the requisite records for controlled substances. You fortunately have some doctors or nurses or physician's assistants that, like everyone else, gets involved in drug issues or addiction issues or alcohol issues that cause their behavior to become out of the norm, where they get reported. And again, there's very good systems within the Department of Health and the Education Department that monitor the physicians, and if there's a problem, to get them proper alcohol or drug treatment so that they can maintain their employment and be safe to themselves and to their patients.
Do you find ultimately one penalty, I suppose, which could occur is the loss of licensure? Short of that, though, what types of other, do they have probations or certain restrictions, or what do you see as a way that they've carved out middle ground?
They do have that. They have suspension periods where you can have a portion of it be an actual suspension and a portion of it be what's called a state suspension, where you can practice, but you're monitored by the department to make sure that you're acting appropriately and conducting yourself in a manner to be safe to to the patients. Because in that realm, obviously the patient is the number one goal and the number one care of one, the physician, but two, the boards that oversee their actions.
Now, you've also told us, too, that there, from time to time, nurses are alleged to have violated the standards that they are required to operate by. And those hearings are done at the Education Department, I think. And what's the nature of that type of hearing, or what are the allegations that can be brought against a nurse? Again,
it's the same type of proceedings, that they're not documenting their charged appropriately, or they're abusing patients. And unfortunately, as you've seen recently in the paper here, you've had allegations of inappropriate sexual contact with patients. And again, it's the same type of system where you can have an informal hearing, or a lot of times there's behind the scenes discussions between the attorneys that are involved. These are the issues, can we resolve it? Because any professional really doesn't want to go through the angst of having a full-blown hearing if it can be avoided and resolved in a manner that's going to be beneficial to everybody.
Do you find that the departments that are regulating either physicians or nurses, that they share their evidence right away and upfront with you and provide that upfront discovery so that it's fully available to you as to what the issues could potentially be, or do you find that there are often roadblocks to actually getting the documents that you'd actually see in a hearing?
In my experience in dealing with the Education Department lawyers and the Department of Health lawyers, they've been very forthcoming. Mm-hmm. These are the allegations. These are the medical records that are involved. This is what our expert is going to testify to if we are going to go forward to a hearing. So it allows the physician, the nurse, or the physician's assistant to make an educated and informed decision as to how they want to proceed. But again, it's just like any criminal case. A lot of times there's allegations that can't be substantiated, and there's some that you have to push back a little harder than others. And sometimes you can even convince them from not going forward and actually forwarding and pressing the charges, or showing the charges and going forward on that end.
You find that now ultimately is the department word the last word, or if you had a hearing at the Department of Health and there was a ruling adverse to the physician, any opportunity for judicial review?
There is. I believe first you have to you can do an administrative appeal first. Then after that, you can always bring an Article 78 to the Supreme Court. But fortunate or unfortunate, I haven't had to go that route where I've had to bring the Article 78 proceeding. And then you'll go in the next realm of, if you have someone that has been suspended, you can go to the restoration process, which is a very difficult process to do, but is a possibility in the end.
do you find that ultimately some type of middle ground is accomplished that with the focus of patients as the net gainer?
In most of the cases that I've been involved in with the professional disciplines, I would say that we have been able to come to a middle ground. There's been a couple of cases that the allegations were of such a nature that the department wasn't interested in negotiating a deal, that they actually had to go forward and go to a hearing. And on a lot of the other cases where the allegations couldn't be substantiated, we've been successful in convincing them not to levy the charges at all.
Well, that's obviously a lot of good work on your behalf for your client. You found yourself recently, last summer, I believe, in a celebrated criminal matter, which went to jury, and which had so many different twists and turns. And ultimately, I believe that your client was found not guilty of the allegations. But it was certainly a case that was well known throughout the Saratoga County Courthouse last summer. Why don't you tell us a little bit about that case, Counselor?
This was it was a real interesting case, and anytime you go through a full jury verdict, and as a defense attorney you get the acquittal, it's obviously a great feeling. But it's going to get there when the jury's out, your heart is certainly pumping. But I had some very interesting facts in this case. My client, I represented an African-American woman who actually worked for the Department of State, who was brought to Albany when her mother couldn't care for her, and spent most of her life at the St. Anne's Institute, and it really was a self-made person. Went to college at Albany and received her master's degree, and a very bright, intelligent woman, and has a daughter. And they moved out from Arbor Hill to an apartment complex in Waterford, so her daughter could attend the Shenendehowa School District. And from the moment they moved into this apartment complex, they just experienced hatred and racial slurs thrown at them by a downstairs neighbor. And it culminated in an incident where my client's daughter was home alone, and the woman downstairs had been slamming some doors and windows and things of that nature. And my client's daughter slammed her foot down on the ground, and the response, which is almost unbelievable in today's day and age, was shut up, you F and N, which you couldn't believe in this day and age would be said. My client's daughter immediately called her mother. They called the apartment complex and notified them. Client was away that day, so the next day she came home. They called the police, notified them of what happened. And later that night, my client heard some more noises and went down to say, how can you scream at my daughter and yell racial slurs at my daughter when you're down here making all of these threats and allegations? And unfortunately, one thing led to another. The downstairs neighbor got in my client's face and was pushing her, and they were screaming. And actually, downstairs neighbor actually bit my client on the lip, left bite marks. And my client ended up getting in a fight, and it was a pretty significant fight. A broken nose, and which was the ultimate injury event. There was a misdiagnosis at the emergency room of a broken jaw, but when the radiology reports actually came through, it didn't show a broken jaw. And so she was charged and indicted on assault in the second degree, which is a Class D violent felony, maximum 7 years in prison. And had she lost that trial, would have had to mandatory state prison of 2 years. So she had a lot of risk, but she was adamant that she didn't do anything wrong, and as she pled guilty, that what was she showing her daughter, and actually left a misdemeanor on the table with no probation, no jail time, and ran the risk of going to trial on the felony. And fortunate enough for me and for her, we were able to convince the jury of I think two things: one, that she acted in self-defense, and two, that the broken nose, while an injury, didn't meet the definition of serious physical injury under the penal law.
Well, that wasn't your first time that you've been in Saratoga County involved in representing clients. I think that you were also involved in a case involving a variety of Skidmore students as well.
That was another interesting case. I represented a Skidmore client who anybody that has a child or a son would want their son to be. He went to Skidmore, graduated Phi Beta Kappa, a member of the hockey team, whatever conference Skidmore is in. He was an all-star within the conference, on the student government, and just the most likable person that you would meet. And again, it's a typical college story. My client's roommate had a girlfriend, and client's roommate was a big guy, about 6'4", on the hockey team, and there was another member of the school that took a liking to his girlfriend and was harassing the girlfriend via text message and in person. And one night they're at a bar. And sucker punches my client's roommate, the 6'4" kid, and just hits him once, flattens him out, and runs out, and then walks around campus for 3, 4, 5 months saying, I took out the big goon of the hockey player, and then essentially went into hiding. Nobody saw him for a few months. Then you fast forward to getting to near final exams. They're all out one night. They see this kid. Words are said. The hockey player that was hit, whose girlfriend was being harassed, takes off from the bar. 3 of his buddies follow him. They go into the house where the other person lives, and the person that was hit, my client's roommate, and the person that was making the allegations, get into a fight, and that's the story. And 20 minutes later, my client is arrested on a Class B burglary for going into a house with the intention to commit a crime, and now really facing with the ruination of his life. And fortunately, the Saratoga County District Attorney's Office really did the right thing in this case. They did a real major investigation and actually presented the case to a grand jury. And within the grand jury, 2 of the 4 kids were indicted on only misdemeanor charges. 2 of them were not indicted at all, and the 2 that were indicted on the misdemeanors eventually pled to non-criminal violations, which was my client. And now we're faced with this lawsuit, actually out in Nassau County, because that's where the plaintiff and the complainant in the criminal case live. So we're in an attempt to get the venue changed to move it back up to Saratoga County, where the witnesses are and most of the people are from. But it's just hard to believe that a college fight and bar fight, and how many people you talk to that were involved in these is ended up in such a major mess.
And among other things, it's interesting to note that it started in a criminal venue, and now it's in a civil venue. And it's all the same people, parties, witnesses, but it's now been pursued in 2 separate types of courts as well.
Right, and it's going to be interesting to see how the civil case plays out. The grand jury failed to indict on an assault, which leads me to believe there weren't injuries, or certainly not serious physical injuries. They didn't even indict on the misdemeanor. And obviously in a civil suit, they're seeking money for the the damages that were ensued as a result of this altercation. Now, in the civil suit, they named the college and one of the coaches of the hockey team. So I think they're looking to go after the dollars of the college, but I hope it doesn't go much further, and I think we've got some good defenses there.
Well, Andy, there's no question that your practice is exceedingly busy, and that you are enjoying success throughout the legal system on behalf of your clients. And I would be remiss in not recognizing the fact that you're the son of an attorney, and your dad, Andrew Safranko, certainly has served and continues to serve as a practicing attorney in the Capital Region, but also served in the Albany City Court for a number of years. And as I was driving over here today and I was thinking about some of the issues that we might discuss, and I was thinking about the influence that parents can have on someone to become or follow a profession that a parent has. And I was thinking about a recent guest that I had, Judge Herrick, our county court judge, whose dad, grandfather, great-grandfather, and great-great-grandfather were all attorneys. And I was thinking about you and your dad, who's also an attorney. And I was thinking about my oldest child, who's now a first-year student at Albany Law School, who went to the same college I went to, now goes to the same law school I went to. And you can't help but think that there must have been some kind of influence at some point in the home on young children to believe that that they wanted to pursue something that their parent had. Did you find that your dad's influence as a judge and as a lawyer had an influence on your determination to become a lawyer and to practice?
Absolutely. My father obviously is one of the biggest influences, in my life, and fortunate enough to been able to watch him, from afar as a kid, going with him to do arraignments on Saturday and Sunday mornings, at court. And I always found the system, to be fascinating. Father was and always prided himself on, a man of the people, and whether it was someone on the street asking for money or the wealthiest of clients, he always had the ability to talk to anybody and relate to anybody, and it was a quality that I admired in his ability to wanting to help people, both through his job as an attorney, as a judge, and through his charitable work. Obviously influenced my life and my decision to become a lawyer. And I was fortunate when I first graduated law school to practice with him for a couple of years, doing a lot of the general practice of law, and could really learn a tremendous amount of how you treat people, how you react to judges, how you appear in court, your demeanor, and just everyday dealings with the practice of law. And then when I was in law school, I also had the opportunity to practice at O'Connell and got in with a great group of people, with Steve Coffey and Tom DeNovo and Pam Nichols, and was able to really learn the criminal work, which I love to do, and some of the civil litigation and the plaintiff's personal injury stuff that we do. And ultimately in 2001, I went back to O'Connell and was able to make partner there. And so I certainly credit everything with respect to my legal career from the beginnings to my father. But I think one of the what your daughter will face is when you start getting recognition for your own work is a good feeling as well. I think when you start, and you see it a lot, we're in a great area that has a lot of father and son teams, and in fact, the first building we practiced in was all father and son law offices. The Brickmans were there, and the Woolseys were there,
right.
and my father's office was in there, and it was just great to have the experience to practice, and also the Darrenesians were in that building. It was a real interesting building to be in, and it's just it was a pleasure to be able to see him, and still to be able to call him and say, "Hey, Dad, what do you think about these types of cases?" and to work back and forth in cases.
Well, no doubt your children too, your two young children, will benefit by your influence and the influence of your wife as well. And thank you for spending some time with us today and the citizens of the town of Colonie. You have a very busy schedule, and we're all very interested in how you continue to practice in the capital region as you move forward, and we wish you the best of luck.
Great. Thank you, Judge. Thank you so much for having me here today. It was my pleasure.
We are absolutely thrilled.
Thank you.
I'm Judge Peter Crummey, and thank you for joining me on Benchmark.